Ladies and gentlemen, welcome to another episode of the BUL International Law Group Emerging Voices series. Tonight we have the pleasure to host here in the BUL campus another important emerging voice in the field of international law. And we are going to take you to a travel along these two sides of the Atlantic Ocean, bridging Europe and the United States. Ladies and gentlemen, together with us tonight, Sarah Zarmsky. Sarah, it's a pleasure to have you here with us tonight, and we welcome you to the BUL School of Law. You have a very important route so far, starting from the US, from Brandeis University, where you had a major in psychology, and then you made the transition to Europe and to Leiden University for your master's in law, the LLM, and now you are in the University of Essex, a PhD candidate, also in the field of international law. Would you like to tell us a bit about your roots and how you envisioned your transition from one continent to the other, and also from one field to another field of study?
Yeah, so I went to Brandeis University, like you said, and I majored in psychology. I had minors in legal studies and French, and Brandeis had a particularly unique and really cool program called Brandeis in The Hague, where they would take 10 undergraduates around and bring us to Leiden University in the Netherlands for a semester. So I went in spring 2017. And it was really cool in the sense that we were undergrads, but we got to take the LLM courses at the master's level at Leiden University. And we also got placed in various internships around The Hague. So I got placed at the ICC and the registry during that time as well. And I just really fell in love with living in Europe. I thought, I come from a small town, Farmington, Connecticut, so there's no public transportation. It's a very different lifestyle, but being in a place where it was so international and I could bike everywhere, walk everywhere, I just fell in love with that way of life. And so when I came back to Brandeis, I had another year. I finished, and I was deciding whether I saw myself as a U.S. attorney or not, and whether to go to law school. I applied and got into some JD programs, but I really just, as you know, American JDs are they take longer, they're 3 years, and they're a lot more expensive. And I just wasn't sold on the idea of being a lawyer yet, and I really wanted to get back to Europe. So I decided to apply to the Leiden LLM program and was accepted for their LLM in Public International Law, which was a bit strange usually they don't accept people without a first degree in law, but they made the exception thankfully, and I ended up doing really well and I loved it. And then after that, I knew I wanted to stay in continental Europe, including the UK. At the time, Brexit hadn't happened. But Essex just seemed like the best fit for my research. My supervisors, Carla Firstman and Dara Murray, are both amazing in what they do, and it was the perfect mix of the international law, human rights, and the tech elements. So Essex just seemed like the best fit. So that's why I ended up here in the UK. But yeah, the transition from psychology to law, I think, is stranger to maybe those outside of the United States, because as Americans, we're used to not having a first degree in law. And it's more of this liberal arts mindset. So psychology also, like in that regard, is not actually like a strange major to have before going to law school, I don't think. I know a couple of people who also did that and had the psych major and then went on to US law school. And I do think that the concepts are more transferable than you'd think. I think there's a lot of connections between psychology and the law. Especially now, I work doing things with technology and law, which is interdisciplinary, combining science and the law. And I think a lot of things like how we think about, digital evidence, possible biases with open source evidence, for example. We use psychology a lot in like criminal cases, like forensic psychology, that kind of thing. So I do think it is more applicable than you would think. So yeah, that's how I ended up here.
And also, we have to state that in international law, we have an emerging field of the psychology of international law. I saw that you wrote your LLM thesis on the laws of war. So in the laws of war, we have mental harm of civilians and all these psychological aspects that need a legal treatment. And this is something also behavioral sciences step in order to decipher the secrets of international law. So we see that psychology is getting an augmented importance in the field of international law. So I think also your BA is going to be very useful also from this perspective. But we also saw that Europe stole you maybe from, at least provisionally, from the United States. But you're returning back to the States now. In January, you're a visiting PhD researcher in Berkeley. So do you want to tell us what are your expectations now? A wonderful experience, but you can tell us what you expect to take from this experience.
Yeah, I'm very excited. Berkeley, working at the Berkeley Human Rights Center has been a dream of mine for a while now. Working with Alexa Koenig and Lindsay Freeman and all the other great people over there. They're kind of leading the way for this field that I'm in on, you know, the intersections between new emerging technologies and international law, especially international criminal law. The Berkeley Protocol is, you know, the key document for using open source evidence in international criminal trials. So they've just done such cool work there, and I'm really excited to get involved with whatever I can get involved with. They have a really great digital investigations lab, which I have some experience doing open source investigation research with the Cameroon Database of Atrocities, which does great work. Also, I volunteered with Bellingcat before and at the Essex Digital Verification Unit. So I'm excited to see how things might be done differently over there, especially because I've never done it in the US. So yeah, it's exciting, but also kind of nerve-wracking to go back because I've been away for quite a while now. I kind of see Europe and the UK as my home, and my life is here now, or my adult life is here. So, but I'm also not from the West Coast, so it's also kind of a foreign environment to me as well, going to California. So
exactly. It's
I'm
going to
excited.
be very interesting also for you as an American.
Yeah.
And to say also to the audience that Sarah Zarmsky has the privilege or the uniqueness to bridge not only between continents, as we said at the beginning, but also in between universities. Leiden and Berkeley, the two universities that have taken a preponderant role in the forming of the optional protocols when it comes to digital evidence. And Sarah, not only this, but you have worked also for both major international courts of our days, the ICC and the ICJ. How would you describe your experience there?
So I was in the registry, both the ICC and the ICJ. My ICC internship was a lot shorter because I did it as part of my exchange program when I was a bachelor student, and I was a lot younger then, so a lot less experience under my belt. But I really enjoyed working at both courts. I think being in an environment like that, it's just so unique in the sense that everyone is kind of coming from a different place in a different legal system, and you can read about the problems that, you know, these courts face, but seeing it in real life really gives you a greater sense, especially as someone who does research right now. Like my PhD focuses on accountability for online harms under international criminal law. So I think having actually been in the courtrooms and, you know, seeing these problems unfold in real life has really informed how I do my research and how I write about it. But yeah, I really enjoyed both of my experiences, and the teams that I worked on were really great.
I take note of what you said before. You saw the challenges behind the lines of these courts. Which do you think are the major challenges that these two courts are going to face in the future, in the near future?
I mean, I think they already do face a bunch of challenges, and I can't say what is, you know, more important of a challenge than another. But I do, from my experience and obviously from my interest in the digital side of things, I did notice that digitalization has been an issue. For instance, when I did work at the International Court of Justice, a lot of our documents were still on paper. They hadn't really had stuff that you could, you know, search for online, like e-discovery. I think the ICC is a bit more advanced in that sense because they've put all of their documents, same with the other international tribunals, all of their court records are online. But I'm not sure that the ICJ has finished that process, but don't quote me on that, I'm not positive. But at the time I was working, they hadn't. So I think maybe how they can use technology to help them with their, you know, daily functions could make things a lot, you know, faster and more organized. But at the same time, there's also risks with that, you know, security risks with using the technology, you know, a lot of risks with using digital evidence, especially open source evidence that you find on social media, for example, that has been up and coming at these courts, especially in the context of you know, Ukraine. We see a lot of videos of like the conflict posted to TikTok, Twitter, stuff like that, and how we can make sure that these videos are, or photos are authentic and reliable, that they haven't been, subject to altering, or, if they can still be used as evidence, that kind of thing. I think those are some key challenges, especially as more and more of the evidence becomes electronic.
And also, as you said before, also the bias that visual digital evidence can also stir in the users and in the wider public. This is also another maybe challenge that has to be underlined. But you spoke a bit and you stressed the issue of technology. I know also in your PhD you stressed the issue of technology, digital evidence. My question is, which role does technology play in your general academic and professional life?
I'm from a generation that's very reliant on technology. I use my phone and my laptop every day. I do not understand how people did a PhD without a laptop. I have a lot of respect for people who did it on like a typewriter.
You're now also a user of Twitter, we have to say to the audience.
Yes, I do use Twitter quite a lot, and I think, it has its pros and cons. Right now, Twitter is not in the best shape with the recent issues of it being handed over to a certain individual. But I think, Twitter has been really invaluable to my PhD experience because I started during COVID, and I was able to connect with a lot of people in my field without having to travel, stuff like that. And you can easily message people, you can find out about people's publications in real time, find out what's going on in the world in real time and comment on it. So I think it's really been invaluable for networking, LinkedIn as well, but I think Twitter more so because it's more immediate. Obviously it might fall. I hope it doesn't, but we'll see.
Do you see that the people of your generation, as you say, the academics of your generation rely on Twitter, or is it something that needs to be stressed in the international law field?
I think it's a great way to get your research out there and comment on issues in real time, regardless of what stage you are in your career. There's a lot of, senior academics on Twitter as well. But I think it also kind of levels the playing field where early career researchers like myself, who maybe normally wouldn't feel comfortable walking into the office of a senior academic, can, reply to their tweets or, engage with them that way. And so it really does kind of make it so that we're all kind of in the same room able to discuss topics, which I think is really cool from around the world.
And the discussion of topics brings me also to the other parameter of technology and international law you're involved into, and this is the blog, Opinion Juris, the famous, one of the important blogs of international law, which is established by Kevin Heller, our friend, and we send also our regards to Kevin. And indeed, it's a privilege to work and to be involved in this blog. How do you experience your weekly engagement with the blog? Or is it a daily engagement? You can tell us.
I think it depends. Sometimes we have, granted, I only started a couple months ago, and I've really enjoyed it so far. There's great people on the team. They've been really welcoming and, treating me like an equal, even though I'm kind of the early career person of the group. But I wouldn't say I work on it on a daily basis. I think there are times, if we have, symposia, like my upcoming OSINT symposium, which will be in February. We recently worked on one with pop culture, which was cool. When you have stuff like that, where you have a lot of posts to edit really quickly and put them all up, we all are really good at coming together and, working as a team. And then weekly I post the events and announcements and deal with the advertising kind of side of things as well. So I think it just really depends on if it's a busy time or not, but I've really enjoyed it.
I will ask you an intriguing question that I pick again from what you said before now. You spoke about the pop culture and international law. How much do you think international law is amenable to new fields, to new voices, to new perspectives? Because the previous generations, we knew about the classical fields of international law. Nowadays, though, we have a call for international law to actually append itself with new fields. So pop culture, for example, how much, or international law in the arts, international law in music, how much do you think that this could be an amenable combination in the future?
I think it's as much as you would like it to be in that sense. Like, of course, there are always going to be people that, scoff at the fact that we had an international law and pop culture symposium and think it's silly. But I think, one of the great parts of having this academic community is that we can do fun things as well. We can apply international law to stuff that, you know, you wouldn't immediately think of, like pop culture or art or music, and it can make it so that it's kind of more accessible in that way, so that, you know, you can engage with people outside of the field. And I think it's a way to, you know, make things more fun, build a community, and apply concepts in a way that could make them easier, I think, especially for students to understand. I think I had some students that I gave some of the blog posts from the Pop Culture Symposium to, and, you know, it really helps them to understand some of these more difficult concepts of international law when they're applying it to something that they find interesting, like a TV show of theirs that they like, for instance.
As you say, very interesting indeed. I think this is the key word. It makes international law more interesting also, and it doesn't make it seem like only such a discipline that has to be taught only in classes and not generally affecting the wider public. I think this is something that has to be stressed. And I think after this nexus between international law and other fields, what about international law and linguistics? And I speak now about you having the minor in French, meaning you had also this touch of languages. So what do you think maybe, and how did French also maybe influenced, if it did, your international law route?
Well, I don't know much about linguistics, but I mean, just speaking from my experience, I think having other languages has been really valuable to me in my career path, because obviously the languages of the courts, like the ICC and the ICJ, are English and French. When I worked at the ICJ, my team was entirely Francophone, and so it was really great that I was able to, like, follow along in the meetings and stuff like that. Like, I'm not a native speaker, but I was still able to follow along and, you know, read documents in French, which has been really, really helpful. And I think, you know, we do have an issue in academia with, you know, only citing, you know, like English speakers tend to cite English work. Sometimes we ignore some work from, like, the Global South, for instance, and stuff like that. And I think, you know, it's important to try and bridge that gap as much as we can. So, I mean, right now I know that some of the blogs, Opinio Juris, and some other ones, I think Afroeconomics, sorry if I got that wrong, but
it's correct, Afroeconomics.
Yeah, are like doing something that has multiple languages, like a symposium. So I think doing these types of things can really help to bridge that gap.
Indeed, and as you say, each language is a different perspective, and when it comes to international law, this reminds me of the book of Andrea Roberts, Is International Law International? And the different jurisdictions, how they see international law. It is not monolithical international law, it's like a synthesis of different perspectives and different voices.
Yeah.
Sarah, it was a pleasure to have you tonight with us, and indeed, we look forward to hearing your further developments in the field. Ladies and gentlemen, we hope you enjoyed our talk with Sarah tonight. It was a pleasure to have you on board, and to wish you a pleasant night, and looking forward to having you joining us for the next episode of the series. Good night.